Alrighty, we're going to get going. Our next panel, actually before our next panel, I'd like to make an announcement. We are going to, we're working on some CLE credits for you all. So those of you that are interested in CLEs, we have a CLE pending. There's a sign-up sheet out at the front registration desk. So any panel that you've attended once you attend, please go ahead and sign that, and we are working on that for you. So our next panel is one of my favorites. It's regarding ESI protocols. So I'm going to hand it over to Mark, and he can do his introductions and whatnot. But glad you all are here speaking on this great topic. And here is Mark from Compliance DS, Discovery Solutions.
Thank you, Kevin. Appreciate it. Appreciate everyone being here. We've got a nice packed room here. I know you guys have a choice in your Masters Conference panel, so we appreciate you being here today.
Thank you for flying ESI protocols.
That's my only joke, sorry. All right, so I'll make the disclaimer. As always, the views and opinions expressed by the members of the panel, along with myself, belong solely to the panelists and don't represent the views or opinions of their organizations or their management teams. And as my wife would say, you and your opinions can go sleep on the couch. So I'm going to let the panel introduce themselves. Danny, we'll start with you down there.
Absolutely. My name is Danny Thugachin. How about now? My name is Danny Thugachin. I am the Practice Technology Director for the law firm of Blank Rome. It's a Philadelphia-based firm that has offices all over the country. I, at one time, had a similar role here at Thompson Knight, and in the intervening period, I was also with Drinker Biddle and Reese. So I've been doing this a little while, so happy to be here.
Hi, I'm Rich Robinson. I am the Director of Legal Operations and Litigation Support for Toyota Motor North America. I have been with Toyota for only actually going on 7 months now, so I'm pretty new to that organization. But I've been in the field for about 20 years, and looking forward to working with the panel.
Hello, everyone. I'm Tony Milliken. I am currently the Director over Information Governance and Legal Technology at Trinity Industries. I've been there for 3 years. That role includes litigation support, e-discovery, information management, legal technology. I've been in this space for, well, 25, 30 years.
Good morning, everyone. My name is Martin Tully. I am a litigator and a founding partner of a boutique law firm in Chicago called Actuate, LLC. That comes on the heels of over 25 years of large firm litigation experience, 2 of which I was the head of e-discovery at. More recently, the head of the data law practice for an AmLaw 100 firm that included e-discovery, information governance, data security, data privacy, Internet of Things, autonomous cars, artificial intelligence, but that wouldn't fit on the business cards. We just called it data law. I currently chair that practice at my new boutique firm, and in other roles, I also am the current vice chair of the steering committee of the Sedona Conference Working Group 1 on Electronic Discovery, as well as a director at large at the Chicago chapter of ASEDS. Thanks for being here.
Thanks, panel. Appreciate it. Looking forward to a great discussion. I'm Mark Zamsky. I'm the COO of Compliance Discovery Solutions. I'll be the moderator today. I'll introduce us to most of the concepts and slides, and then we'll go to the panel for some opinions. And of course, please don't be shy. We value and welcome your questions, your opinions, any insights. This should be a collaborative session, and you guys are, what, 30, 40 people out there? We're 5, so there's a lot more opinions out there than up on the panel. As we go through our presentation and discussion today, we've sort of broken this down into some major parts regarding ESI protocols. And of course, when we sort of discuss the general concept of the ESI protocol, we're thinking about this mutually and sort of voluntarily agreed upon plan on how both parties are going to preserve and access and review and produce data. They're not required. Although taken literally, one could look at Rule 26 and say that it's a very good suggested practice. Sedona principles recommend that ESI protocols are part of the entire cooperative or cooperation initiative between counsel. And ultimately, though, they really can't be forced unless they're in a court or jurisdiction where they're required. But ultimately, the ESI protocol is going to set the ground rules for what might be highlighted in our e-discovery practice. It's going to preview what might be important. And to some extent, Rule 26F9 with the discovery plan sets out some of the sort of general major themes that we might want to discuss within an e-discovery protocol. So we're gonna break this down into 4 areas: scope, format, privilege, and miscellaneous considerations. Before we start, I want to take a little poll. Hands are great. I'm glad we have a lot of folks in the room. The people in the back have the advantage of cheating, looking at what people in the front are saying. But let's go through this. I'm going to give you all of the answers, and I just want to see by a show of hands as we sort of call this out. So the question to the group is, and the panel, please raise your hands as well. What percentage of the time do you use ESI protocols? I've broken down into some percent. Just by show of hands, how many are using ESI protocols less than 25% of the time? All right, 25 to 50? Couple, 50 to 75, much better proportion. 75 to 90? Over 90? I got 1. All right, very interesting. So it looked like 50 to 75 seems to be the majority there, although it's pretty evenly split. All right, next question. I customize my ESI protocols based on the nature of the case and type form of data anticipated. We got rarely, sometimes, most of the time, and nearly all the time. How about rarely? Sometimes, couple, most of the time. That's a better showing of hands. Nearly all the time. That's that sort of middle ground there really takes the prize. All right, third question. When using an ESI protocol, I find that motions and disputes with opposing counsel either decrease, increase, or stay the same. So how many see motion practice and disputes decrease? Increase? That was good. Stay the same. All right, minority. All right, so let's jump into this. I think that's really instructive as to where everybody is and gives us a nice feel for what people are experiencing out there. Let's talk a little bit about scope. And of course, before we get there, I think one of the topics we want to discuss is whether or not we even need an ESI protocol. And we talked a little bit about court mandated, right? 7th Circuit Court of Appeals requires it. Some courts in Colorado require it. Some of the additional considerations are, are we in federal court and are we being guided by Rule 26 or in state court, and what are the state court rules? And some of the other considerations, and Martin, I'm going to go to you to talk about some of these, but do we want to use our ESI protocol, draft it before we go to meet and confer, and actually use it as a strategy, right? When I was in law school, we talked about, negotiation tactics, and showing up to a negotiation with a pre-drafted document or resolution was always just a great way to go. It sounds silly, but do I already have a form? Because if you have drafted an ESI protocol from scratch, that's not fun. How much and what type of data is expected, and whether or not there might be anticipated disputes. Is this a hotly contested litigation? What's counsel like on the other side? And what might you be trying to limit in terms of your data? So Martin, if you want to expand on some of these concepts, what are some of the factors that someone should take into consideration on determining whether or not an ESI protocol is even necessary in a given case?
Sure, and there's a threshold question to address first, and is to make sure that we're talking about ESI protocols that are either negotiated and stipulated to with the other side or blessed by an order of the court. I want to draw a distinction between those and ESI playbooks, because any organization that engages in any amount of routine litigation should have ESI playbooks, which may be their internal-facing plan for how they go about doing the things that we're going to be talking about today. So we'll set playbooks aside and talk about that outward-facing version, which is the protocol that either gets approved by a court or stipulated to with the other side. So the question that was asked is, why would you want to do this, and why wouldn't you want to do this? So let's start with why you wouldn't want to have an ESI protocol. First of all, ESI protocols are like insurance annuities. They're not for everyone, and they're not for every case. You have to understand the product before you purchase it and how it works, otherwise you can get burned. So not every case needs an ESI protocol. There are some cases where even spending the time to go through the discussion might not be worth it. The sophistication of the case, it's not a one-size-fits-all type of situation. You always need a plan, of course, whether you're going into your 26F conference or your Rule 16B conference with a court or the state law equivalents of those rules. You want to have your plan, of course, but you don't always need an ESI protocol. And let's not forget Sedona Principle 6, which says that the producing party is best situated to identify and figure out what it's going to produce and how it's going to produce it, right? This leads into sort of the KISS principle, keep it simple, stupid. Why overly complicate something that doesn't need to be overly complicated? Mark mentioned opposing counsel. There may be some opposing counsel that the very notion of trying to negotiate an ESI protocol with them is probably more painful than the underlying merits of the litigation. So you kind of have to figure that out. Lack of uniformity across cases. I'm going to give you one side of a coin I'm going to pick up in a moment here. Maybe you don't want to have an ESI protocol out there because if you're litigating in one jurisdiction and all of a sudden someone pulls out in another case your ESI protocol and says, well, now I know what you have to agree to because you used it in another case with a different counsel in a different place. Maybe you don't want to have that. There's also the famous quote from Don Rumsfeld. There are the known unknowns and the unknown unknowns. And sometimes trying to capture everything in an ESI protocol could be overly ambitious and unnecessary. And if you haven't figured this out yet, don't agree to anything that you don't understand. I've seen too many people just blindly agree to ESI protocols and 6, 9, 12 months later, what? I have to do what? And they just didn't even realize what they were getting into. That's a big mistake. So why would you want to have an ESI protocol? First and foremost, as was mentioned, you may have to have one. There are a number of jurisdictions, and Mark named a few, that require by either local rules or standing order that the parties submit and enter into an ESI protocol. So that's always a good idea is to follow what the judge says. There are also other times where it may be required by that particular court or other matters. It's usually a good idea when you're dealing with complex cases with multiple parties because you don't want to have multiple different forms of production. For example, if you have a case with multiple defendants, for example, sometimes an ESI protocol where everyone is sort of reading from the same hymnal can be more efficient and cost effective. If you are a frequent flyer and you're a serial litigant or you're representing a serial litigant that has cases all across the country in different jurisdictions, you don't want to get caught up with doing one thing one place and something else the other place and then being accused of being inconsistent, hiding the ball, and all those other things. So having ESI protocols can help take that internal facing consistency and make it more externally consistent across multiple litigations. It forces early meet and confer. Rule 26F 3C goes through the things that you need to talk about in that planning conference for discovery, and you have to talk about all these things anyway. So having an ESI protocol or going into that meeting with something already in hand forces that early collaboration, cooperation, and proportionality. It also can be strategically advantageous. I said earlier that you don't want to agree to something you don't understand. But you'd sure like your opponent to agree to something that he or she doesn't understand. So sometimes I send out the ESI protocol and the other side just agrees to it. Oh, great, fantastic. I'll wait till I call you in 12 months and tell you what you agreed to.
Martin, thanks. Any other comments from the panel? Some of you look like you're chomping at the bit to talk. Danny, go ahead.
Well, a couple things. One, Texas takes a very loose stand in state law as far as how much you can ask for, or how much you have to ask for. And so inevitably the practice here has been Rule 11 agreements. Parties sending an email communication back and forth saying, hey, this is what we want to ask, this is what we want to get, do you agree? And just reaching agreement via email. One thing that I've faced a lot, and I think Martin touched on this, is that I get a lot of boilerplate ESI agreements. Somebody else, the e-discovery chair in the law firm, drafted a great ESI agreement that they used in a huge litigation, and an associate comes along and repurposes it for the purpose of this small matter that you're, that now has crossed your plate. And those are proposed to us from the other side, and our attorneys don't want to really engage in that conversation because it's far outside the scope of the purpose of this litigation. So what do? How do you push back on that enough to lighten the burden, but just get past it? And that is the ongoing challenge that we have whenever these protocols come across our plate. in the smaller matters. Large matters, exactly. Martin's the kind of guy that you want on a large matter that's going to engage in that negotiation process in a deep way. But the small ones with giant boilerplate ESI agreement protocols have been a real challenge for us.
Danny, thanks.
I would
Tony.
just like to add that from the in-house perspective, I think one of the real reasons why you would want to have ES protocols, even if you're not actually out there and it's something that's being filed with the court or you're working with your meet and confer, is that you've set a precedent of a guideline of a repeatable process. So you already have an edge in the game. You already are showing. So if someone does pull out that other order and say, well, this is what you did. Oh, yeah, that's repeatable. It's the same. Those are the guidelines we always follow.
Rich,
Yeah, I just want to echo what Tony's saying, right? So from an in-house perspective, we're not at the table in that 26F, right? So it's important for us that our outside counsel, discovery counsel, is very familiar with our ESI playbook, but then probably already has an ESI protocol form in hand. If we haven't already worked through all the details on what's actually going to be used as an ESI protocol for this particular case, they should all be very aware of what our standard process is.
great. Well, it's a perfect segue into our next topic because I'm going to tee the next question up for you, Rich. Some factors that we want to think about including with the protocol, or I probably should have written on here, potentially excluding from the protocol. And again, we need to continue to keep in mind that these are not required. They're agreements between the parties. So do we want to list custodians despite our Rule 26 obligations? Do we want to have a specific list of custodians and limit or expand who they are? Again, dates and times and scope of preservation. It doesn't necessarily lift anyone's scope of legal hold, but if we can limit date parameters with the opportunity to potentially go back and object if something else comes up, how do we want to address that in an ESI protocol? Data sources are critically important because data sources aren't just email and Microsoft Office documents anymore. We're dealing with multiple data sources with multiple platforms that are becoming more and more difficult to assess. How do I preserve? How do I collect? What format? What does it look like? How do I review it? Discussions of what is considered accessible versus inaccessible, and how do we use the federal or applicable state rules to determine what is an undue burden or cost on a party, and whether or not, again, we want to reserve our rights to go back and look at what might be considered accessible or inaccessible. Proportionality becomes an issue, and one other topic that should be discussed are non-parties, right? Subpoenas. When we send out subpoenas to all non-parties, regardless of the side, do we want to attach the ESI protocol so that we're getting consistent production formats, and how and in what format do we want to receive that information? So these are in the terms of scope. These are things that we want to try to determine either as an expansion of what we want from the other side or a limitation on what we want to produce. So, Rich, when you're working with outside counsel, what are some of the considerations that you have or discuss that would either indicate where you want to take a more restrictive or a more liberal approach, and how does that maybe differ from what one might experience from an in-house legal team versus what outside counsel might want, which don't always align,
Right.
and then also internally what some of the stakeholders in this litigation, right, your custodians, how they feel about it?
Yeah. It's a great question, and it's also a question that I could probably sit here and talk for the entire hour on. And I would love to workshop it with this entire panel and go through a potential ESI approach, ESI protocol approach. But I think just to bring it down to its simplest terms, most times in my career, I'm acting as defense. Right, and my approach to the ESI protocol is generally an attempt to limit the discovery, right? So I very rarely would recommend getting into specifics in an ESI protocol, if at all possible, avoiding naming data sources and talking about which ones you can and cannot get data from, naming custodians in the ESI protocol, actually agreeing on keywords up front. These are things that that I would recommend we try to avoid at the beginning of an ESI protocol discussion, right? My experience has been that ESI protocols tend to be somewhat living documents. They start one way and they end somewhere completely different. So in the beginning, as I approach the construction of an ESI protocol, it's usually an attempt to limit the number of custodians to 3 to 5 key custodians, data sources that are relevant to the specific matter, avoiding, I often will leave off anything like ephemeral data unless it's specifically relevant to the case. So we don't have to get into discussions of data sources that are not even considered in the scope of the case. Same with date ranges. That's one thing that I probably try to organize and set up early in the ESI protocol is what's the scope in terms of date.
So you mentioned data sources. Danny, what are some of the considerations that we have when it comes to all of the new data sources that are not necessarily on our Exchange server or Office 365? Not that Office 365 is easy to get anyway, but what are some of the considerations for all of, Slack and chat and ephemeral messaging or IoT data?
Well, start with, do you know what you have? In most organizations, when I'm having a conversation with IT, they'll say, we have this policy, we believe there are these systems available. Then we start talking to custodians, and we realize that they are using messaging in ways that IT is not aware of. So inevitably, the technology is changing every few months. There's a new protocol, a new process. Facebook Messenger goes from being open to encrypted. The collection process, iPhone changes their SMS platform, messaging platform, and suddenly what you could do with Celebrite last week, you can't do anymore. And so it's this continuous change process. In the context of the particular litigation that you're working with, you're going to have to go test. Hey, if I'm going to commit to doing these things in the CSI protocol, can I really deliver on it in this context? For corporations that at least have some more control over your own instances, I think you can develop that, doing the data map exercise and saying, what new technologies are IT going to roll out in our organization so that we can have a grasp of that in legal before it goes into production. Legal is not always looped in. In fact, legal seems to be always get the last opportunity to have a say in, are we going to Office 365? It seems to come to legal last. That said, for the outside counsel role, we're thrown into a new circumstance every single time. And we're having a new conversation, and most of our litigants are not serial litigants. So they don't have ready answers to this, and it becomes me explaining to our associate and partner how to engage in that conversation with the client, how to interview the individual custodians, and explore this. So it's an exploration each and every time.
Tony?
I just want to add on that too. I mean, let's be transparent. Who knows the data best? It's going to be in-house e-discovery teams. They know the data much better than your outside counsel knows that data. And so for me, I'm going to do everything I can to avoid to do any collection until it's required, number one. But I'm going to make sure I'm educating my outside counsel and giving them some guidelines for protocol of here's what we're going to anticipate. This is what we typically see on this type of case. We're going to avoid that broad collection until it's absolutely necessary. If you've got the right program, you're doing preservation in place, you're avoiding those collections before doing that broad stroke and then creating a repository of data that now you're holding on to, and then the next case comes, and then the next case comes while you're holding on to all these broad collections, while you have all of these requirements for data minimization within your corporation that your litigation partners are not thinking about.
I feel like we're playing Jeopardy here. Rich and Martin both have their fingers on their mic buttons.
What is Trenton, New Jersey? All right, well, I guess I got to talk now.
Yeah.
A couple things I do want to add where you may want to be specific in an ESI protocol comes in the context of preservation. And preservation may not be something you can always do in an ESI protocol because you may not have an opponent yet, but I'm in the scenario where you have an opponent and you're able to sit down and have this conversation. As part of Federal Rule Civil Procedure 26F, you now, since 2015, have to include in your conversation issues regarding preservation. So why not deal with that in your ESI protocol? The other thing you may want to deal with specifically are any inaccessible or not reasonably accessible sources of ESI. And from the defense side, the reason to front that is to let's deal with it because I don't want to preserve this stuff for whatever reason. So instead of sort of sitting back and waiting for that hand grenade to explode, take it up front and say, look, here's why I'm not going to preserve this. Here's why I'm not going to go after this kind of source of ESI because it's not readily accessible under 26B2B, if that still exists in the world of proportionality, but that's another panel. So sometimes that's a smart thing to get up front and get that kind of specificity because you either get the agreement and now it's off your back, that monkey's off your back, or if you have to get guidance from the court, you can get it early on. You can't always do that because sometimes you don't have a judge or even an opponent yet, but that would be one place that specificity in the ESI protocol might make sense.
Yeah, no, that's an excellent point, and it just calls to mind, in terms of data sources, that difference that Martin brought up before of the ESI playbook versus the ESI protocol. It's absolutely necessary for corporations to have an ESI playbook in place where they've identified it, at least to their discovery counsel, what those data sources are that are very difficult, because if we have to put them in the protocol, they should know ahead of time. It doesn't necessarily have to be in the protocol unless there are reasons to do so, but they do need to know about them.
So we didn't prep this question, so it comes with a little bit of a warning here. So this is something that has sort of floated around in many of the different panel discussions and conferences I've been to, but do you think that for businesses, it's getting harder and harder outside of backup tapes to argue on inaccessibility of data because of the sophisticated platforms we're using now, the divergence of platforms in the cloud, not understanding necessarily how or where data is stored, right? So I'm just curious, if any of you guys want to address that inaccessibility and what the sort of approach is to trying to avoid the difficulty of doing that. Danny's got his hand up. I like that tactic.
Well, this is actually a comment I wanted to make to Rich's earlier answer. It depends on the judge in some circumstances. I mean, how much of the judge's attention do we want to draw to this issue? And are we dealing with a plaintiff or an opposing party that is going to try to turn this into a conversation with the judge? There's a lot that we can get into an ESI protocol and agreement about proportionality in the context of trying to get forensic collections off of iPhones. It comes up for me all the time where the data is not accessible, and we would have to take extraordinary efforts in order to try to get to that data. If we're able to engage in a conversation, reach an agreement with the other side, and take that off the table, absolutely, we want to do that. And then the strategic element is, between the burdens between the parties, and the equivalence of burdens, and being at the defense side most of the time, feeling overly burdened with what's being asked of us. So, yes, with all of the new technology and the changes that are going on, I think you should be contemplating that, making it part of the conversation, and getting it documented whenever possible.
Tony?
Well, I would argue, well, obviously proportionality is key to that, but I also think that it's important to make sure that, that argument has always been, oh, it's inaccessible. Typically it is accessible. It's about educating your outside counsel and your in-house counsel. Hold off on making that argument first. Maybe it might be a burden, but it's accessible. Maybe there's another avenue that we can take before we go trying to make that argument and then going before the court. And I am not a big fan of making that argument because I know what we can and can't do. It's a lot easier than it was before.
No doubt.
There's a saying that with enough time and money, everything is accessible. And that's where technology has gone. And it used to be that if you talk about backup tapes, oh, well, we're not going to touch those. Those are not reasonably accessible. It's not the case anymore. So that's the bad news. The good news is, as Tony said, is proportionality is your new weapon of choice, or shield, call it what you want, where you can say, okay, fine, maybe with enough time and money I could get that information, so I'm not going to argue that cost and burden, and frankly, that the burden of proof to show that may not be, what is that phrase, the juice may not be worth the squeeze. Proportionality can be a much better approach and simply say, look, in the grand scheme of this case, why? Why are we forensically collecting all these cell phones from 3,500 people? Why? Are there other ways to get to what we need to do? Yes, we can do it, but why? So I think proportionality, while cost shifting and not reasonably accessible still exists within the federal rules and state law equivalents, proportionality is a much better path.
Martin stole my thunder again, so.
I gotta stop doing that.
Ditto. No, but and that is the approach that I often recommend that we take is an argument of proportionality. I mean, what you can go into these obscure databases and run keyword searches against these complex old databases, which is a lot of times what we're dealing with large companies, large enterprises, right? But is it reasonably anticipated to produce anything relevant to the case? And if so, is it duplicative of what you've already collected in the case? So does it matter? So you can make those arguments, and I find those are easier to reach an agreement with the opposing counsel on those merits rather than trying to make an accessibility claim.
Sure. Let's continue on scope, and let's shift it to various aspects that, again, could or should not be addressed in a protocol. And specifically when it comes to search and filtering and review methodology. Deduplication, do we want to scope out a specific hash value and how deduplication is going to be done? Does the production need to have and capture and produce an all-custodian field so that even though we only produce one copy of a document under a particular custodian, we know every other custodian that has ever held on to that document? With culling and review, there's no rule on transparency. Remember, these are voluntary agreements. So when we talk to clients about predictive coding or the use of advanced analytics, like, I'm gonna have to run that by the other side. And I'm like, no, you really don't have to. Like you can just go ahead and do it. There's no real authority that says anywhere that you have to defend your search methodology in advance, and the burden is on the receiving party to claim that there has been some issue with your production in order to go through the sort of maybe the validation process here, which is the discovery on discovery process, which is always a great topic to discuss and could probably be another full panel. But so Tony, let's just focus on analytics for a second. And considering in today's world the sort of cost and time involved in manual review of data and the sort of widespread acceptance of analytics and TAR, how much do you feel you need to reveal to the other side, either in a ESI protocol or not, about your search and review methodology?
Well, I think you can take two approaches to that. First of all, it has to do with the sophistication of the parties. You may not even want to bring it up. If they're not serial litigators, you've already given the guidelines to your outside counsel. They're aware of what that methodology is, that repeatable process that you're always going to use within your organization, and they've been made aware. When you're looking at trying to determine when it comes to TAR and analytics, I usually just leave that off the table. I think it's more about just how you're searching, how you're collecting that data, how you're doing the deduplication of that data. But when it comes to whether it's email threading, or are you going to do dedupe at the custodian level, or are you capturing all the custodians that have that information, I think if you're following that same process, repeatable over and over, and outside counsel's aware of that process, and if you have the opportunity to engage and educate the outside opposing parties, that's great. But if it's not something that needs to be discussed at that time when it comes to TAR and analytics, I kind of hold that and I let outside counsel make those decisions.
And so just to be clear, you may not discuss it in an ESI
Yeah,
protocol or
protocol.
with opposing counsel,
Right.
but you'll tell outside counsel to go
Absolutely.
ahead and utilize TAR.
If they want to use, now there is some TAR that we have consistently that we've already told our outside vendors that we want them to always use. We make sure that our outside counsel is aware of that.
Great. This is always a hot debated topic. So anyone on the panel want to chime in? Danny?
I actually completely agree. I advocate to our attorneys to always do email threading and only be reviewing last inclusives. But I don't suggest that we're only going to produce the inclusive change. The technology makes it really easy for me to produce the entire document population, have everything tagged consistently, and produce it. So why engage in that discussion? We're using email threading, we're using the analytics and the technology. If I'm asked to defend it, I basically explain to the partner and opposing counsel that I'm using relativity or widely accepted, commonly used practices that are specifically addressed in the Sedona principles, and I say this is standard practice. I have not gotten pushback saying, oh, no, you can't use that technology. In fact, the bigger problem has been the DOJ and the FTC saying, oh, TAR will make this really cheap. So why don't you go ahead and apply TAR to that entire document collection and spend a couple $1 million on getting this review done for us.
Except that you then can't review it after you apply TAR with the DOJ and the
And we went
FTC.
to the judge in that circumstance and we got that pulled back, but that tends to happen more often.
Any comments from the audience out here? Nothing. All right.
While they're thinking, this of course could be another panel, the eternal battle between the titans of Sedona Principle 6, which I have tattooed on my forearm, which is that the responding party is best situated to figure out how to identify and produce information in response to requests. And then, of course, cooperation. Both of those things you'll find in the federal rules. Both those you'll find in numerous case sites, both at the federal and state level, as well as throughout the Sedona publication. So it's this eternal battle between cooperation, which would suggest that you bring the other side in and say, hey, we're going to use TAR. I'm not going to show you everything, but let's try to front some of these issues and eliminate disputes down the road, as opposed to the alternative, which is Principle 6. I'm doing what I want, and until there's some indicia that what I did is not compliant, you don't get to get into my underwear drawer.
And what I come back to our partners with is, and ultimately you're certifying the production, right? You are certifying that you've provided a complete and accurate response to the discovery demand. And if you're able to do that and sleep at night, then you're fine.
So let's just take it from the other side for a second. We've looked at this from the perspective of us being the producing, reviewing party. So, Danny, are you saying as well in your response that because technology makes these things so easy that if the requester says, I want email threading, or I want to capture the custodial field, or if you use TAR, I want to know your methodology, or at least that you engaged in TAR, are you more apt to just agree to those things?
99% of the time, yes. I mean, the ESI protocol will cross my desk and I'll get a request. Does this make sense? Can we do this? And it's now probably been 2 years since I looked at that and said, no, there's something in there that is going to be extremely burdensome for us to be able to generate. It's gotten a whole lot easier, to Tony's point earlier.
Yes.
In the context of the litigation, labor employment matters are the ones that I think I deal with the most, where plaintiffs ask for too much and try to really shift the burden onto our client. In that context, usually the partner's kind of ahead of me because they're, it's proportionality, and they understand proportionality now pretty well. Most of it is, it's going to take a little bit of extra effort for us to produce that field. It's going to take us doing a little metadata manipulation to create that request. But we're very standardized on the tool sets that we're using. Most folks are now using a concordance and now relativity DAT. We have a pretty common standard set of fields. We've been doing this for 15 years now. I don't get really far out of left field kinds of requests that often that it wouldn't be more than an hour or two of extra effort or a request to Mark's team to be able to, hey, can you turn this around for us? So it's, if you engage in 2 or 3 hours of conversation with the other side, the cost to the client has already exceeded that.
All right, so let's move on because this leads right up to form of production, and I think it's an important aspect to talk about. And I think that most of these things are standard and should be addressed in an ESI protocol. So the only real question then is, to what specificity do we want to ask for? And so with respect to images and natives, are all black and white images okay, or will they stop us having some sort of meaningful rendering of an image? What type of files do we want to look at that are produced in native? And going back to understanding data types, do we even understand the data types and how they're going to come out through a collection or a production or some sort of TIFF image other than in an Excel spreadsheet, which has somewhat become the standard, and do we understand how those files should be produced? Parent-child relationships always important. I think it's pretty standard that we keep those together, but then when we talk about privilege, do we redact on parent-child? What makes a document privileged or not privileged in a parent-child relationship, and how do we produce those things? And then obviously load files and deliverables, which gets me to my question to you, Tony. How are you dealing with counsel that either doesn't know what to do with a load file because they don't have the technology, or if you don't have an ESI protocol in place and outside counsel fails to request?
I was just saying,
Yeah.
she's attending 2 conferences
She's double
at once.
webinar. She's cheating on us. Wow. She's recording this, giving another presentation on ESI protocols. Okay, and then the other side of that is, okay, you got a load file and the council doesn't know what to do with it, or you don't have an ESI protocol and you don't ask for form of production and you get a single PDF with 10,000 pages on it. So what do you do?
Unfortunately, it's going to happen. I mean, we're dealing with, where we're situated, and a lot of the litigates that we work with are not sophisticated. So we anticipate we're going to get those 10,000 pages that are not native, and we're prepared for that. We anticipate it. Unless it's something that's going to be overly burdensome for us, we're ready to tackle it. We tried not, and we're prepared to help guide the opposing party if they don't understand how to load that data, and give them some guidance and be transparent so that we can make sure that our outside, the outside counsel, opposing counsel, they're arguing the law, they're not arguing about the discovery. That's what our job's here. That's why we're here. We're to help with that process.
Do you ever deal with counsel that says they can't actually produce a load file for you, and that you got your PDF?
Yeah, and then that's when we try to see if they're willing to maybe partner with our vendor, help them with that process. We do encounter that sometimes, yes.
So Morton, in terms of productions, we've talked about special file types. What are some of the considerations we should be thinking about when it comes to these data types that can't be produced in a TIFF format or need some other type of native production or other special format?
Right. Well, this is where thinking, looking to the end to dictate what you do up front becomes very important. And this is where the trial lawyer in me looks at a data file and says, okay, how am I going to use that in a deposition? How am I going to use that in an evidentiary hearing? How am I going to use that trial? How am I going to show this to a jury? And when you're dealing with things today, such as social media content, you're dealing more and more with emojis. And if you don't know this, emojis render in different ways depending on what system they're sent across. So things that can look like a toy ray gun on one person's phone can show up as a Colt 45 on another phone. Those can send very different messages. So a lot of attention has to be paid up front as to, is this going to be important information? And if so, how is it going to be displayed and rendered to a judge or a jury or the government or whoever it might be that's looking at it? And so mine needs to be paid towards how does that get collected in a way that can be displayed in a way that people are used to seeing it. And that can go on and on for all different other types of information. Who had access to it if you're in some kind of a shared or collaborative environment. Those things need to, if those are important, you need to think about those early on and maybe make sure that your requests for when you specify your form of production that you're saying that up front, so if the other side turns around and gives you something you can't deal with, you can point to it. Yeah, see, but right here I asked for this form of, I specified this form of production and you didn't object, so guess what? You're producing it in that form. The rules provide for that. And then real quickly, this is an unscripted answer to your question, which is what do you do about structured data? This comes up all the time. More and more instances of structured data can be far more powerful than the unstructured data that we're used to dealing with. How is that going to be produced? You're obviously not going to turn over a database in rare situations, but you can turn over either samples or reports or, again, other manifestations of that structured data that may be important to the case. If that's an issue, then it should be addressed and specified up front.
You're looking at me like I have an answer. And remember, I'm just the moderator, okay?
No, you had the question, and the question was, what do you do with structured data?
Mark, I'd add to the structured data and the native data question, one sentence to include in your ESI protocol is you will not refrain, a reasonable request to produce the native will be accommodated. In most circumstances, that you can create the rules any way you like, but in a specific circumstance, instead of having to go to the judge to say, hey, look, we need to see the native version of that document, it's a very standard element to include in your agreements, and that takes away from a lot of the direct confrontation over the protocol.
And I assume it goes back to scope and our data sources, right? If we're collecting cell phones, we need to think about the various data on cell phones. If a database were in a marketing or you're going to think about whether there's a Salesforce database or other database to consider. Joy?
Yes, I have, and actually, that's a very good question because I've had clients who will remain nameless who have said to me, oh, well, here are the reports that we can issue, and that's it. Well, that's only the tip of the iceberg because that's all they ever use the system for. And you want to be careful about that because someone need only look at the Google machine and pull up the entire protocol for that operating system and say, well, actually, you can run the following 52 reports. Your staff just doesn't know how to push the right buttons. So yes, that does come up, and then it's a question of understanding if you're using a piece of software to run a database, or today there's databases of all different types of things. Your car is a database, your refrigerator is a database. There are more and more databases, different forms of information. Understanding what can be produced and in what formats above and beyond how you may typically use it. I mean, how many of us use the full capacity of our phones? Very few. It's like our brains. We only use a certain percentage, but they can do much more. So understanding that is important, and I would argue also consistent with the ethical duty of technical competence.
I just really want to add on to that quickly that if you have that process of understanding ahead of the game what structured data may come into play, and if you know that you're anticipating that, making sure you have that confidentiality order or that AEO order in place, so that you can actually produce that in a form that's not being seen by your opposing party.
This is like a rehearsed dance. It's a great segue to privilege and AEO stuff. So let's talk a little bit about privilege. I probably should have flipped this slide around and put the form of Privlog last. But when it comes to privilege, I think, again, critical to include in every ESI protocol, and as a supplement to that is a 502D order, obviously in federal court or in a state court, similar provisions. But clawbacks, absolutely, production of privilege happens. It's not just vendors that do it, but everybody produces privilege. well, we're the ones that get yelled at. Of course, confidentiality, protective orders, and attorney only should be things that are contemplated and considered up front, so we're not always running to the court to determine any sort of manner of designating that. If the parties can come to an agreement with that, it's always really important. And then the form of privlog, right? Some of our jurisdictions are requiring categorical privlogs, which of course then filters through the remainder of the legal community. And now that's the hot buzzword. And can you run a categorical privlog and then sort of your presumptive priv, right? So post-litigation filing or communications with outside counsel presumptively privileged, and they don't need to be on the privlog. These are things that should be considerations. So, Danny, I just want to talk a little bit about 502D orders. Are there cases where you think that that's not warranted?
From a practical sense, I don't work in the 502D world directly very often. So I might defer that to Martin or.
You know what? Rich, let me ask you that question, and then Martin.
Okay.
Rich, are there?
Yeah, if for all of us who were at Legal Tech, if you were sitting for the judges panel, I think it was Judge Peck who basically said that you have to have a 502D protective order in every case. And I'm going to echo that. I really think that there's no reason not to have a protective order in place. It doesn't preclude you from the duties and responsibilities to review the data before it's produced, but it just doesn't make sense not to have.
I'm curious for those of you that have federal cases, are you using 502 orders pretty much all the time? Yeah? Okay.
So this time Rich stole my thunder because I was going to tell the Judge Peck story where he basically says that failure to have a 502D order is tantamount to malpractice. And he said that multiple times. So I agree completely. I cannot imagine why you would ever not want to have a 502D order in either a federal case or in a state that has rules of evidence that track the federal rules, like my home state of Illinois. The thing to be careful about, though, is you still see lawyers out there that are putting 502B language into their 502D orders, which defeats the whole purpose, because 502B is the inadvertent disclosure, and you have to demonstrate, number one, that the disclosure was inadvertent, and you have to demonstrate you took reasonable steps to avoid it, and there's all this stuff you have to prove. Well, you don't need to do any of that in 502D, so take that 502B language out of there and just go with the 502D. Judge Peck actually has a model order that he wrote when he was on the bench that's out there, and I don't think anybody's improved on it yet.
Or what people are doing is they're not including that language in an actual order and having judicial sign off. They're including that language in the ESI protocol, thinking
yes.
that is
Yes,
the
it's a
same or
502D
similar protection, which it's
order.
not.
And Mark, then I'll say on the other side of that, once the order is enforced or there's a discussion with the outside counsel about how that clawback is going to occur, then it comes into my world and I'm asked to implement that. And in that sense, that happens all the time.
All right, well, let's go back to your world then. Let's talk a little bit about data confidentiality. Any recommendations for you on how to sort of pre-identify and be proactive about confidential data, not privileged data, but confidential data, and how it should be treated throughout the process, right? How far back do we go on this, like to the custodians and corporation?
Often the custodian, the corporation, the conversation with IT already stages the PII issue, and as to what they're turning over to us. So in the context of a particular litigation, it will be that conversation with in-house counsel and with legal and with IT to identify what we're expecting to receive. That said, the generation of tools that we're dealing with now, we're able to do entity extraction up front. We're able to do a lot of PII identification up front. And then we have a whole class of confidential documents and business secret documents that the clients are asking us to keep an eye out for on the front end. So there, again, as we stage the data, we do our early case assessment, and we make that part of the searching and vetting process of the data that we bring in. So we want to pre-tag that as much as possible before it even gets into the reviewer's hands.
Great. I'm going to move on. We've got one more slide, one more topic, and about 5 minutes. Yes, Joy.
I honestly have not seen it yet.
You can. Again, there are other types of logs that you can engage in. Federal Rule 34 says that you have to respond with some specificity to a request, particularly since the 2015 amendments, so that if you were withholding something on the grounds of whatever, you have to say that and then explain what you haven't produced because of that objection. And it could go beyond privilege. It could be other things conceptually that you might use. And then, of course, the other side can always challenge it, but you can't just withhold it. You have to say, I'm not producing this because. I would recommend anytime you know an issue like that is going to be an issue up front and it goes to the real core of the case and it's not some peripheral thing that's just there to run up the bill. But if that's really an issue in the case, you're dealing with trade secrets or crown jewels, then absolutely. I would take that right up front, deal with it, and if the other side doesn't cooperate, go to the judge.
So real quick, just some miscellaneous items. In terms of negotiation, some of our jurisdictions require an e-discovery liaison. Seventh Circuit Court of Appeals has a whole program for that. Northern District of California, I believe. And the question is, how do e-discovery liaisons assist with sort of dispute resolution rather than sort of a large motion practice, which begets sort of the issue of everybody sort of getting along. And I'll ask the panel a question as the last question, and we can go through it. But just some other items are whether or not we want to address rolling productions and if that's acceptable, adherence to deadlines, and then I think the panel has sort of spoken a little bit about, and Martin's highlighted it in some of his colorful speech of traps for the unwary, which is, going back in 12 months and being like, no, you agreed to that right here, and so you owe this to me. So again, so important to really understand the entire scope and obligations of the parties, which gets me to the last question that I'll throw out to everyone. And Martin, we can start with you and go straight on down. But it's become a boxing match to some extent with respect to ESI protocols. Some parties try to use them as a sword, some as a shield. Some want them, some don't want them. Some want reduced scope, some want a huge scope. So what are some ways that parties can work better together, going back to the Sedona principles tattooed on your arm, that everybody can get along when it comes to ESI protocols?
Sure. Well, what really helps with the ESI liaison is, in the Northern District of Illinois and other places have a requirement that in any case involving ESI, and what case doesn't involve ESI, that each party is supposed to appoint an ESI liaison. The liaison doesn't have to be the lawyer. It can be more than one person, but the combined entity needs to be able to be very familiar with both ESI best practices, e-discovery best practices, and the technology and the data involved. When you have those people in the room, I suspect if the 5 of us up here were in a meet and confer as the appointed ESI liaisons for our respective interests, we would probably work things out quite well. So that's one of the reasons to have an ESI liaison, is it's someone who, okay, we all have the same things tattooed on our arms, we know how this works, we're not going to take unreasonable positions, we're not going to try to produce 8,000-page PDFs, that's just nonsense. We're not going to even argue about it. That helps a lot, and it also helps to get an ESI protocol in place. What I think the real problem here is twofold. Number one, you have a lot of unsophisticated people out there that either are using boilerplate, as was mentioned earlier, or they don't understand what they're agreeing to, or they just blindly agree to something, and that can be problematic. But I will say one word of warning. And that is even trying to get reasonable people who are knowledgeable in this area to agree on what should be considered as part of an ESI protocol is very difficult. There was a Sedona exercise in Working Group 1 where they tried to have a brainstorming group to get people from both the requesting and the responding parties, as well as government, as well as the bench, talk about, well, what would be the things that would go in an ESI protocol? And they couldn't agree upon anything beyond form of production. Just because there were people didn't want, well, I didn't even want to talk about that, so I'm not going to put it on the list. But there is nevertheless an 8-page single-space list of potential topics that were identified that have come up in the course of history, if you will, in ESI protocols. So to go back to the very beginning of our conversation, sometimes the juice isn't worth the squeeze. It depends on the case.
Tony?
What he said.
Rich, you stole your line.
No, you go ahead.
You know, ladies first.
Yeah, I mean, I just following on what Martin said and kind of going into the traps for the unwary, I think that you have to be careful about ESI protocols when they come across the desk. I find that it's, if they're being entered by plaintiff's counsel, I have to look real close at them. And a lot of times it's outside counsel has not identified some of the concerns that I see in that space. So as in-house counsel, as corporate counsel, it's imperative for us to be reviewing what's being sent across. It's a shot across the bow, and a lot of times it's overly broad, and and sometimes it's just messy. I mean, I got one not too long ago that had both summation and concordance fields listed in the required fields. I could tell that it was just somebody had a couple of old ESI protocols and just meshed them together because they thought that made the most sense. So, you know, those kinds of things happen. So you really have to be wary. You have to be reading the protocol all the way through. So that would be my only suggestion.
I'm going to take my turn back real quick, only to say that I 100% do agree with that if, you know, sometimes your outside counsel may be going in and agreeing to some protocols, and they have not ensured that you are engaged in that. We highly recommend that it's going through and you get a look at that, making sure that they're not promising that something that's going to be an issue throughout the case.
Danny, last word. This is the calmest I've ever seen an audience right before lunch, just so you know. There's no one's fidgeting in their chair. It's great.
I'll say, just to Martin's point earlier, which is if two reasonable people are sitting across the table from each other with the comprehension that everybody in this room has about what the issues are, it really should be about the strategic elements of each party's position. You know, there are plaintiffs that do want to shift the burden, and it's up to the defendant to protect themselves from having too much of that burden shifted onto them. But you're no longer going to be about the mechanics or the forms of production. You're going to have a conversation about strategy and tactics. And then law firms and lawyers are going to do what they do best, which is try to win. And that's just a different conversation than whether, you know, we get something in a TIFF or a PDF and what that needs to be. So,
Thank you. Thank you to the panel. Thank you, everyone.
And thank you, Mark, for a great panel. And again, thank you, panelists. So we're going to have lunch now, and we have several speakers for our lunchtime enjoyment. So lunch is going to be outside. We can grab it and come back in here and eat. And then our next regular panel is going to be at 1:30. So that's a wrap for now.